Mr. Hutton, just before you continue, did you have a chance between all of you to speak about timings over lunch?
We did. Unfortunately, we think it's tight. I plan to be, I've got to go to the authorities and I've got to deal with indemnity costs. I plan to be an hour and restrict myself to that, or you will restrict me to that. And then Malona from Sawila thinks he's going to be a total of 3 hours. And then in response, Mr. Cowan thinks an hour. And I should be shorter than that, I would imagine, but maybe half an hour. Well, actually, I doubt I'll be half an hour in response. I'll probably be 15 minutes.
I've probably got my arithmetic wrong.
Yes.
I think I've got to 1:45 tomorrow if we had no break
Yes.
for lunch.
Yes, exactly.
Which is obviously beyond the allotted period.
Yes.
I think we could go to a little bit beyond before 15 today, but I know at least one member of the court had, no, it's not possible at all. And I'm afraid we can't start earlier than 10:30 tomorrow because I'm a member of the Constitution giving a judgment at 10 o'clock in a case where there is a hand down in court for various reasons. If it really came to it, we might go a little bit beyond 1 o'clock, but it was allocated a day and a half.
Yes.
So we'd like it done in a day and a half, please.
Absolutely. That fully in mind, and I will try to refer to skeletons, etc. Where I can. So, in terms of the main judgment in this case, I just wanted to refer to a few bits of it because it is obviously relevant to the eventual costs of all. And that appears at tab 9.1 in the core bundle at page 87 onwards. And I'm sure that the court has had an opportunity to consider that judgment. I would submit that the judgment is very thorough, very well reasoned, with the greatest respect, and I think it's. I have to say it is in some contrast to the judge's judgment on costs, which is admittedly extempore and not reserved, but is particularly brief and we would say fairly poorly reasoned. It pains me, obviously, as someone who argues about costs a lot, that cost is relegated in that fashion, but it does seem to have been rather relegated. So, with that introduction, the judgment deals with an introduction until paragraphs 10, then it has the assessment of the evidence from paragraph 11 onwards, and the assessment of the various witnesses involved, including obviously Houssein between paragraphs 18 and 22, and the finding that at paragraph 22 I do not believe Hussein's evidence in respect of any of them was complete. In key regards, I do not believe that it was given dishonestly. So, given honestly. So, in effect, he found that Houssein was aware at some stage, and paragraph 20 does say, I do accept that he may not initially have appreciated that there was prohibition on his family residing at 71 Hamilton Road, but it seems to me very clear that he did know of that prohibition by the 29th of July, which was the date of the inspection. So that's his finding in relation to Houssein. His finding in relation to Mr. Leon Dares is at paragraphs 27 through to 32. And effectively, he is extremely damning off in paragraph 30. He says that he gave evidence in what he perceived to be his own self-interest with scant regard for the truth. It is the case that he found Mr. Leon Dares was my client's agent, but of course he was the respondent's witness in the case. And effectively, he made findings that Mr. Leon Dares and Mr. Stylianides were in cahoots together in terms of presenting 71 Hamilton Road as being empty and not occupied. And at paragraph 35 of that is his finding of dishonest evidence about that. The photographs were simply staged, and he knew that the property was occupied and wished to create the impression that it wasn't. Then there's assessment of Mr. Theophanus, who is the Theophanus, who is the credit manager, and it was found that LCL's credit manager didn't know anything about this, these stage photos or anything of that sort. Then there's the assessment of Mr. Griffiths and Mr. Kyriakou, who were the experts, and that obviously is relevant to the question of the interest rates. And he said he preferred the claimant's expert on that. Then he deals in a passage with evidence that was not before me, and there's a battle about Shakespeare plays in relation to this, and which Shakespeare play is appropriate Hamlet or Henry VI Part 1. But effectively he says he's not influenced by the evidence that wasn't before him. Paragraph 53 deals with the terms of the loan. Paragraph 57 starts with the history of the matter, and at paragraph 66 there's the assessment of the 30th of June 2020 meeting, and the conclusions in relation to that are at paragraphs 95 and 96, so that's a significant issue as to what was discussed from that, and the conclusions at 95 and 96 are that the meeting did discuss a change to the loan structure so that the LCL loan would be taken out by CEK to replace all existing debt. Did not specifically address the requirement for the Husseins to vacate 71. None of this was explained to Mrs. Hussein in Turkish. And at paragraph 96, a move to 61 Hamilton Road, where a family member lived, was never discussed at the 30th of June meeting effectively. That move was something he found was made up by Mr. Leondaris. It simply wasn't the case at all at paragraph 96. So the 30th of June meeting was important. Then he deals with the appointment of the solicitors and the conveyancing process right up to the 29th of July, which he starts at paragraph 133, and he makes his findings in relation to the 29th of July and the inspection. Paragraph 140 says, I have no hesitation rejecting the evidence of Mr. Leondaris and Mr. Stylianides as not simply mistaken, but dishonestly. And he sets out his reasons for why, particularly the stage photos. And at paragraph 41, he says, in my view, it would have been obvious to anyone that the Husseins had not moved out of 71 Hamilton Road by 29th of July. And he refers particularly to the photographing of not the main fridge, but a fridge that was somewhere else, which happened to be empty because their main fridge was full of food. Paragraphs 146 and 147, he concludes that the report that Mr. Stylianides gave to the underwriting team at LCL none of it was true, and that he was fully aware that it was untrue. There is then a section on Mr. Fari's advice, who was an independent solicitor who gave advice in relation to matters. And then at paragraph 159, there's the position at drawdown, and he summarises as to what everyone knew at the time of drawdown. At 159, firstly, Hussein knew that 71 was a security address and knew that the Husseins were prohibited from living there at that time. He understood that the inspection was in Sherrard. Then secondly, Mrs. Hussein did not directly know that it was to be used as security and didn't know that she was precluded from residing there. Then he makes findings in relation to Mr. Leondaris. He knew it was a security address and he knew that they weren't supposed to be living there. And at little 4, Mr. Stylianides may have believed that the Husseins were going to move out before drawdown, but he knew as of 29th of July they had not done so. He worked with Mr. Leondaris and Hussein to create the impression they And then the solicitors, SCW, believe that Husseins had moved to 61 Hamilton Road because they'd been told so by Mr. Leondaris. Little 6, LCL, apart from Mr. Stylianidis, thought that they were living at 61. But then there's the drawdown and discovery section, which deals with when an independent team went to assess the property to see if somebody was living there in September. And he makes adverse findings both in relation to Houssein, that he knew what was going on, but also in relation to Mr. Leondaris about that. Then there's a section dealing with, at 174, dealing with from who did Mr. Leondaris act, and he concludes that he was the agent of the Husseins. And then he deals with the claims one by one, and the first one is at 181, is sham. And essentially he summarises the argument there that the purpose of the loan to CEK was actually to provide money to Mr. and Mrs. Hussein, and disguised by the use of CEK so as to permit LCL to give in effect a regulated loan when they weren't entitled to do that. They weren't regulated to do that. Now that, in my submission, is a fairly short legal point. There would have been very little evidence relating to that. There might have been some extra discussion of the initial meeting on the 30th of June when it was decided that CEK would be the recipient of the loan rather than the Husseins personally. But the reality is that that meeting would have to have gone through anyway, and paragraphs 95 and 96 includes conclusions in relation to that meeting, nearly all of which are relevant to the question of, well, the issue of the event of default. So that would have to have been dealt with anyway. And so sham is then a fairly short legal point. Didn't take up much time, we submit. His conclusions are clear that it was perfectly acceptable to do it through CEK. In paragraph 188, he said it was that Mr. Theophanos had said that it was normal practice. Then at 189, he deals with breach, and that's obviously, we say, the most important issue. At 195, he then deals with penalty, which is being cross-appealed. And then at 210, undue influence, the influence on Mrs. Hussein by her husband, late husband, Mr. Hussein. Again, we submit that there's very little evidence specifically in relation to undue influence. The judges obviously assessed Mrs. Hussein as to her knowledge, her intelligence, her abilities, etc. He would have to have done most of that exercise anyway, because Mrs. Hussein's knowledge about whether 71 Hamilton Road was a security address, whether there was an obligation to move out, etc. All of that was highly relevant to the question of the event of default. So there would have been we would submit very little specific evidence dealing with the undue influence matter. He would have to have assessed most of those issues anyway.
But wasn't the undue influence meant to be in relation to using various properties as security?
Yes.
So it was discrete from the issue of whether or not 71 Hamilton Road was or was not meant to be occupied.
Yes, that's right. that is right. But in terms of separate evidence about her knowledge and intelligence and abilities to deal with those matters, it would have been, we would submit, very, very limited indeed. And then in relation to the consumer claims at 233, both those failed on the basis that they can only be, there's one under the Consumer Rights Act and one under the Consumer Credit Act, both on the basis effectively that those have to be brought by individuals, and the difficulty for the claimant, and it was related to the sham, was that the loan was to a corporate identity, and that was really the end of them. In my submission, very short points which wouldn't have taken up much time at all. So when we say that the right analysis, and this clearly wasn't the judge's analysis, was that there should have been a comparison between the issues of the event of default and default interest, which was the reason why the litigation came about in the first place, compared to what extra costs have been caused by running these additional arguments. The judge didn't grapple with that at all. He just went down the issue-only road. But if he had done so, which we say he should have done so because we were the successful party overall, he would have or should have recognised that the extra cost, the extra time, it wasn't negligible, but it was a very small part of the overall whole because nearly all that evidence would have to have been adduced anyway. So that deals with the judgment. Can I then come on to the relevant rule?
Before you do that, can I just ask you this question while it's in my mind?
Yes.
In the event, I'm interested in the consequences of these submissions in the event that the appeal succeeds on the construction point,
Yes.
and the or the cross appeal succeeds on the
Yes.
penalty. To what extent do you adhere to your case on costs in the event of either of those appeals succeeding?
So if
On the first point, you're say €40, you would say.
yes.
But what if the penalty cross appeal succeeds?
Well,
Speaking hypothetically. Now.
Well, I have to say that then costs would have to be grappled with again in the light of that, because the penalty issue is obviously a significant one in terms of figures. And although we would have won on the event of default, we wouldn't have won on the default interest.
So would it be more difficult to argue that you were the overall winner in those circumstances?
Well, I would still argue that we were the overall winner because we won on the event of default, and that was the prompting of the whole action.
And what about
from that?
What impact would it have on your submissions on the offers?
Well,
Some of the offers might have beaten or got close to the ultimate award, but others wouldn't.
I think
or have you not done that calculation?
No, in relation to the default interest, at the time that all the offers were made in March, April, May, if there was no default, there was no right to default interest at that stage. So all those offers are still good offers at the time.
March, April, May.
Yes.
Because the default interest would only apply after the term.
After the return.
So the offer, the point of the offers argument is a good argument in respect of the first three, but you no longer rely on the whole string of 7 in the way that you can.
Well, it's all the offers up until the repayment date, so 2 of the offers, 6th of October and November. Sorry, 14th of October and 1st of November. Those 2 are we have to reevaluate them.
Okay, but
because default interest would be.
That doesn't affect
the
broad
thrust
on
of
the earlier offers.
No, exactly. And if they'd accepted any of those offers, of course, that would have resolved the whole situation.
So in short, although the penalty argument, if you lose on the cross appeal,
yes,
that on one view weakens your arguments. It doesn't weaken it significantly.
No, we would submit that in terms of the discount, which we argue for, that discount would be slightly larger if we lose on in terms of the cost below, if we lose on the default interest point.
But
it
doesn't affect your submission.
The
overall issue, the issue approach was wrong.
Yes.
Either way,
yes.
Whatever the outcome on any of the appeals. Thank you.
That's right. Samuel, can I just take the court to the relevant rule? I don't know whether everyone has a white book available or.
Not an up-to-date one.
No, it hasn't changed recently, my lady. 44.2, which is in the up-to-date one is 1375, page 1375.
Can I just? I'm not.
You haven't got it.
There's a whole pile of books behind it. Can I just get a look?
We're certainly not going to get to the point where we have up-to-date ones, but I think we might find
We
3
all have-
out-of-date ones.
We all have 2022 versions, I think.
Okay, well, I
Yes.
think
This is savings in the cuts.
yes, absolutely. So it's 44.2. And so 44.2, 1 sets out the fact that the court has a discretion whether costs are payable and the amount of costs and when they are paid. And then subparagraph 2 is if the court decides to make an order about costs, the general rule is that the unsuccessful party will be ordered to pay the cost of the successful party, but B, the court may make a different order. Then subparagraph 3 doesn't apply here. And subparagraph 4, in deciding what, if any, order to make about costs, the court will, I emphasise that word, will have regard to all the circumstances, including A, the conduct of all the parties, B, whether a party has succeeded on part of its case, even if that party has not been wholly successful, and C, any admissible offer to settle by a party which is drawn to the court's attention and which is not an offer or to which the cost consequences under Part 36 apply. And then subparagraph 5 says the conduct of parties includes conduct before as well as during the proceedings, whether it's reasonable for the party to raise or pursue a particular allegation, the manner in which it's done it, and whether the claimant who succeeded in whole has or in part has exaggerated its claim. And then subparagraph 6 is relevant. The orders the court may make under this rule include an order that a party must pay a proportion of another party's costs, and then various other options. And F is costs relating only to a distinct part of the proceedings. And then subparagraph 7, before the court considers making an order under 6F, it will consider whether it is practicable to make an order under 6A or C instead. And we say that's relevant here because there is an order which is purely on the basis of 6F, namely the issue-based costs order, and the judge ought to have considered before making that order whether it was practical to make an order under 6A, which is a proportion, which we say he ought to have done. So the sequence is, as my Lord Justice Newey said, the first thing you've got to do is under 44.22 decide who is the unsuccessful party or the successful party. And that gives you your starting point. And you can then depart from that starting point to B, the court may make a different order. And then you look at the factors in subparagraph 4 in deciding whether to depart from that starting point. And we say, briefly in relation to that, the conduct of all the parties, well, we say that includes, it feeds into C, so I won't repeat myself. Whether a party succeeded on part of its case, even that party had not been wholly successful, we say that's us.
I'm sorry, where were you reading from?
Sorry, 44.4.
Yes.
Sorry, 44.24.
Yes.
B.
B. Thank
Whether
you.
a party
Sorry.
succeeded on part of its case.
No.
Even if that party's not been wholly successful. We say that's us. We've been successful, but we've not been wholly successful. And then C, obviously, any admissible offer to settle. Well, it's agreed that these offers are all admissible. And the judge was obliged to take that into account because it says the court will have regard, including. And
there's no reference to offers in the consequential judgment.
there is, but very brief. It's at paragraph 18, and perhaps I will. Can I then come to the judgment itself, which is in the core bundle 9.2, and
Sorry,
the
just give me a moment.
yeah,
Everything's
absolutely.
collapsed. I'm sorry about that.
Yes, core bundle
9.2.
tab 9.2, page 140.
Thank you.
So looking at this, paragraph 14, it's the costs judgment starts. The judge refers to 44.22, which we've just been looking at, the general rule that the unsuccessful party will pay the successful's costs unless another order is more appropriate. And then at 4(4), that in deciding what order, if any, to make about costs, the court will have regard to all the circumstances, including the conduct of the parties, whether a party succeeded on part of its case, and any admissible offer. So he sets out the relevant rule. Then he says, at paragraph 15, the starting point in this case is somewhat unusual, it seems to me, and should be the conduct of the parties. I found that Mr. Houssein, Mr. Leondaris, and Mr. Selenides all gave parts of their evidence dishonestly. Moreover, in all three cases, the elements of the evidence in question were not minor or peripheral. It's formed a significant part of the position advanced and significant time taking and breaking it down in cross-examination. It would, in my view, be wholly unacceptable for the court to exercise its discretion on costs in favour of parties advancing such evidence so as to allow them to recover the costs of it. Now, firstly, we say, no, the starting point is not the conduct of the parties. The starting point of the rule is to decide who's been the successful party. The conduct comes in later as to whether to depart from the general rule that the unsuccessful party will pay the successful party's costs. He's got the starting point wrong in our submission. And then at 16, he says that the cost of preparing those witness statements will be disallowed, which we say, well, maybe, yes, but that doesn't really grapple with the cost order that's got to be made overall, because the costs of preparing those witness statements are going to be relatively minor in the grand scheme of a case which went to a 6-day trial. And then at 17, and we've obviously referred to this already, as a success, I do not view either party as an outright winner in this case. And we say he's got the test wrong. It shouldn't be who is an outright winner. It should be who is the successful party overall, the successful party in the real world, phrases of that sort. And he had to grapple with that issue and come up with a decision, and we say it was clearly us for the reasons that I've already articulated. And his reasoning for refusing to come to identify the successful party in paragraph 17, I've already dealt with it. In my submission, it doesn't provide substantial reasons as to why he couldn't have made that decision. But instead, he's backed out from making the decision. And the fact that the issues were distinct doesn't mean that you don't have to make that decision. As I say, in some cases it's frankly impossible. It's a score draw. But in this case, we say it wasn't. And he hasn't really grappled with that. And he hasn't grappled with why the litigation came about in the first place. And then at paragraph 18, and this obviously goes into indemnity basis costs, but he says in terms of the basis of costs, the defendants seek costs on the standard basis. The claimants, by contrast, argue for indemnity costs. Both parties had reason to fight this case and to fight this case very hard. Mrs. Houssein risked losing her home. London Credit was accused of serious statutory breaches, a point remarked on by the claimant's own expert, Mr. Griffiths. With hindsight, and this is the one reference to the series of offers that were brought to his attention and brought to this court's attention, with hindsight, the defendants would have been better accepting a settlement. Equally, the statutory claims, despite their seriousness, ended up with something of a whimper at trial. Such things are common in litigation, however. Once the dishonest evidence is taken out of the equation, this case strikes me as robustly fought and not out of the norm so as to justify indemnity costs. Now, we say there are a number of difficulties with that. He appears to be saying that although the defendants would have been better accepting a settlement, such things are common in litigation. I assume that refers to both the statutory claims ending with a whimper and better accepting a settlement, but I don't know, it's a matter for your lordships and your ladyship. But if that is his conclusion, he's completely disregarded the rule which requires him to have regard to offers, to admissible offers. And he simply discounted them and he must have discounted them because his pure issue-based cost order inevitably cannot have taken into account the offers.
Do the words "with hindsight" also rather water it down?
Yes, with hindsight. I mean, of course, you know, it is always the case that until you have judgment, you don't know whether an offer was a good one or not. So there is an element of hindsight in that assessment. But the court proceeds from the basis my judgment is correct, and therefore, you know, you were wrong to refuse these offers.
It's not a matter of hindsight.
No, it's not a matter of hindsight, but it is with the judgment in mind. Until you know what the judge has decided, you don't know whether that was a reasonable offer or not. You know,
I mean, there are obviously specific rules about Part 36 offers,
yes,
but the draconian rules relating to Part 36 offers don't quite chime with, well, these things are just common in litigation.
no, absolutely not. So he has that we say is a clear error. He's disregarded that part of the rule. He's disregarded all those offers, or he's discounted them so much. They've had no impact at all on his cost order. And that is the only reference to them. And then when he says once dishonest evidence is taken out of the equation, strikes me as robustly fought but not out of the norm. Well, I'll come to that. But you know, clearly in an application for indemnity costs, you can't take dishonest evidence out of the equation. That's obviously centrally relevant. And he then, therefore, ordered the pure issue-based cost order. There is no reference in that judgment to subparagraph 6 and subparagraph 7 of CPR 44.2, which encourages him, if practicable, to make an order on a percentage basis rather than on a purely issue basis. There was then some discussion about that after he'd given judgment, and the transcript appears at page 142, the next document, tab 9.3. And at page 143, at line 14, Mr. Maynard, who was representing my client, said both of us are anxious about the task of the cost judge in identifying what evidence and what matters went to which particular issue and separating those out. We seek to avoid, wherever the incident cost goes, is having a very extensive and complex exercise for the cost judge, and any guidance which the court can give now for the cost judge as to how to apply these provisions. For example, what element of the costs related to the consumer claims, what I call generally the consumer claims or the FUSMA claims, what extent that actually affected the trial. As you observe, perhaps by trial these have become something of a damp squib. Yes, and then over the page, Mr. Maynard refers to the evidence of Mr. Theophanus and that he was an honest witness. And then at line 8, the judge says the straightforward point on these claims is that they occupied very little, if any, time at trial. I think there was some time spent on them in closing when I asked you about them, but not a great deal of time. Yes. And then he goes on, and cost judges are accustomed to determining that on the basis of submissions from the parties. What I have no visibility of and no idea of is how much time was spent fighting out those before it came before me. That will be a question in the usual way, scrutinising the emails and scrutinising the exchanges and the timesheets. Well, in my submission, he wholly underplays the exercise that the cost judge will have to carry out with absolutely no guidance from the court. And then insofar as he says, well, I have no visibility, I know what happened at trial, but I don't know what happened before, it behooves him, doesn't it, to look at the issues and think, well, how much time could have been spent on the FUSMA claims? They were a short legal point. You know, it can't account for a massive amount of preparation for trial or pleadings or whatever. You know, again, we say he's backing out from making a decision when he says, well, I just don't have visibility of that. And then at line 20, he says, yes, I do not make an issue-based order lightly because I'm conscious that there is a lot of work that goes into it. It is simply that on this matter it seems to me appropriate, given the success of on both sides, and the fact that it cannot readily be reflected in a percentage discount of either party's costs. I do not underestimate the scale of the task. It doesn't explain why it can't be reflected in a percentage discount, because it is very common that parties don't succeed on every issue, but judges are able to make percentage-based orders if that's appropriate. And then at page 145, there is a reference, line 3, Mr. Maynard refers to, there is one other issue which took perhaps more time at trial, in respect to which there will no doubt be a lot of crossover with the interest with the case of breach. That is the issue of undue influence, which I suspect that my Lord might think that in terms of evidence, although it featured in the evidence, it did not take very much evidence, and did not take very much of the submissions, although of course my Lord had to deal with it in a judgment. He says yes. So he doesn't disagree with the idea that undue influence did not take very much evidence. Mr. Maynard says, but where the balance lies might be helpful for the cost judge to know. I'm not sure I understand the question. The question is this: the undue influence, to what extent is an issue that the court takes up substantial time at trial? And the answer is, given that we have transcripts in this matter, I think that it would be something that would be done by reference to the transcripts. Trial was 4 or 5 months ago. I do not have a precise recollection of how much time was spent on it. Again, we say the judge is backing out on that. The idea that you turn up before the cost judge and go through the transcripts of a 6-day trial in order to work out exactly what issue was being discussed at what particular time is pretty horrific. And the judge underplays it by saying, well, just look at the transcripts.
Well, that's because he's made an issue-based decision.
Yes.
And what quite reasonably or understandably is happening is counsel is saying, how big are these issues? Can we not have some idea?
Yes.
Whether it's to reduce the assessment or whether it's to be able to come to some agreement about this. Well,
yes.
How much do you think? And he feels, presumably, reading between the lines, that he's being pushed in a way he doesn't want to be pushed.
Yes.
And if he'd been able to answer these questions, no doubt you would say he would have been able to come to a percentage-based decision in the first place.
And there's no good reason why he couldn't do that exercise. He hasn't articulated a reason why he couldn't have done that evaluation assessment. Well, can I just then deal with some of the authorities? I think I will deal with them briefly, and I will be done in my time. So the question of starting point, we can go to the authorities. I know there is more than one bundle. Might be quite helpful to start off with tab 7 and decision of Medway Primary Care Trust at another and Marcus. I can deal with this briefly. So this was a case where it was a clinical negligence case where the claimant had suffered an amputation of his leg. As a result, he alleged, of negligent treatment by GPs who'd not identified the problem with the leg. And he won on breach. Breach was admitted, but he lost on causation in the sense that the judge found that the leg would have been lost anyway, even if the GPs had done the right thing. But the judge awarded him £2,000 for the fact that he'd had some pain and suffering for a few weeks as a result of their delay in identifying it. But the leg would have been lost anyway, so it was just an extra bit of pain. The question was, who was the successful party? And the judge found the claimant was the successful party. He'd recovered £2,000, even though his claim was for more than £500,000 for losing the leg, and there'd been no Part 36 offer or other offer by the defendant. So the claimant was the successful party, and he awarded the claimant 50% of the cost of the action. The case went to appeal, and the decision was reversed, and it was held that the defendant was the successful party because, and we'll see at paragraphs 46 and 47, this is the judgment of Lord Justice Tomlinson. 46, the starting point of the inquiry is, as all accept, to identify the successful party. Although there have been many attempts to describe this surprisingly elusive process, no description is in my view better than Sir Thomas Bingham, Master of the Rolls, in Roach in 1998. The judge must look closely at the facts of the particular case before him and ask who, as a matter of substance and reality, has won. Has the plaintiff won anything of value which he could not have won without fighting the action through to a finish? Has the defendant substantially denied the plaintiff the prize which the plaintiff fought the action to win? Now, pausing there, we say that the claimant in this case has won something of value which she and they could not have won without fighting the action through to the finish. They have a finding that there was no event of default, and that therefore they were not going to lose their house. That is something of real value, and that's why we say, together with the fact that they don't have to pay default interest as a result of the alleged event of default, and therefore they have won something of real value which they couldn't have won without fighting the action through to a finish. If they'd not brought the proceedings, they wouldn't have been able to do that. Has the defendant substantially denied the plaintiff prize on which the plaintiff fought the action? Well, we say not. I know that my learned friend will say, well, he refer to the to the other claims, which would have got rid of interest as well. But you know, we refer to the offers and the fact that our position was we're going to pay all that, but we shouldn't have to pay default interest. And then paragraph 47, he says, looked at as a matter of substance and reality, there is in my judgment no escape from the conclusion that the claimant lost his action. £2,000 is of course a substantial sum, but it is not compensation for the loss of the lower leg, and it is of no value to the claimant in meeting the financial needs imposed upon him, etc. The award of £2,000 is in truth irrelevant to the purpose of the action. And it's an example of where the court has to grapple with, in reality, who was the successful party. So that is that. And then there's a case, Brit Inns, which is at tab 9, I assume in the same bundle at page 146. This is a decision of Mr. Justice Coulson, as he then was, in 2012. It is, at paragraph 2, he says it was a personal injury claim. He says, this litigation has gone wrong for everybody. In the main action, a subrogated claim against insurers' losses where liability was never, no, sorry, it wasn't a personal injury claim, I'm getting confused. Where liability was never an issue against a pleaded claim of 660,000 odd. The claimants recovered 157,000 odd. Their recovery is thus about 25% of what they claimed. It cost them a lot of money, and then in a separate claim, they recovered just £16,000, recovery of 3%. The result cost them £157,000. Don't have figures for the defendant, but it seems likely. They too will have had hundreds of thousands of pounds. So it was litigation that had gone horribly wrong for everybody, but that did not obviate the task of the judge to decide who had been the successful party. It's not good enough to say, oh, well, you know, therefore you can get your cost of your issues. Paragraph 50 in Mr. Justice Coulson's judgment, the first issue under CPR 44.3, it's now 44.2, is the identification of the successful party.
Sorry, that was paragraph
50. Sorry.
Thank you so much. No, you did say. The identification of the successful party, in some ways, this is a slightly artificial question here, because for reasons already given, no party in this litigation could objectively be described as successful. I apprehend that every party is going to be out of pocket in one way or another, but the court has to decide which of the parties in the main action has been successful, even though, as Lord Justice Patten stressed, paragraph 22 in his judgment in Hullock, that decision is only the starting point for the consideration of costs, and success alone will rarely be the sole determining factor of liability. And so his finding at paragraph 54 was that the successful party up to May 2012, when an offer was made, was the claimants. And the usual rule
should apply, but that is subject to questions of conduct under 44.34. And he then discounted the claimant's cost to 60% of their costs because the case was exaggerated. And then at paragraph 69, he says this: in my judgment, the position changed when on the 16th of May 2012, the defendant made its Part 44 offer of 267,000, together with 85,000 way of costs. That offer was open for acceptance until 30th of May. So it was a combination of a damages and costs offer. So it was clearly not a Part 36 offer. That offer and its non-acceptance fundamentally changed the cost position for the reasons set out below. First and most obvious point is that the defendant bettered this offer, certainly in relation to the sum of damages, etc. And the same point at paragraph 71, precisely the same point can be made about the defendant's subsequent Part 44 offer.
But you're not suggesting that there should be any before and after style cost order?
No, I'm not. Because the offers were made so early in this case that it doesn't really apply. And so he ordered that the costs after the 30th of May 2012 be paid by the claimant to the defendant on the basis of a Part 44 offer. And we say that's of significance. So 2 points. Firstly, you've got to grapple with who is the successful party, which the judge failed to do. And secondly, Part 44 offers, in contrast to Part 36 offers, can obviously be game changers and was a game changer in that case. Okay, lady, I'm going to shorten matters. Can I take the court in terms of to Birchall and Bullard, which I've referred to already, but only briefly. It's tab 4 in that same bundle. This was a case where it was a claim brought by Lord Justice Ward calls a small builder, but I mean a builder that wasn't part of a large business, and there'd been a dispute with his clients, and paragraph 2, the builder submitted a bill for £13,500, and eventually at paragraph 4 brought a claim for £18,000 unpaid bill. And the defendant's, paragraph 4, counterclaim for £100,000 plus further damages. And eventually, at paragraph 5, in the middle there, builder got judgment for his claim in full, £18,000. The defendant got £14,000 out of a claim for in excess of £100,000. And the trial judges said, well, claimant won on the claim, defendant won on the counterclaim, so claimant gets the costs of the claim, defendant gets his costs of the counterclaim. And Lord Justice Ward said that that was not right. At paragraph 30, he said this: his error, in my judgment, was to fetter his discretion and not go on to consider, as he should have considered, what alternatives were available to him. The most obvious and frequently most desirable option is that signposted in CPR 44.36a, that's now 44.26a, but it's the same rule, namely to order a proportion of the party's cost to be paid. The recorder had directed his mind to paragraph 6f, namely ordering costs relating only to a distinct part of the proceedings, but he appears to have overlooked paragraph 7, which required him, where he would otherwise have considered confining cost to part of the proceedings only, to make instead, where practicable, an order under paragraph under 6a for a proportion of the cost. Ordering a proportion of the cost obviates all the difficulties he acknowledged in an assessment of how much is properly to be allocated to each and every issue considered in isolation. Better by far to decide, despite the difficulty and imprecision of the calculation, that the relevant issue or issues should bear a percentage of the cost taken overall. As the recorder erred in principle, the appeal on this aspect must be allowed. And we say, almost 840 all right, that's this case. That the judges approached it purely on the basis of issues without going on to consider whether that he should be doing so. In this case, he's simply not identified who is the winning party, and he's then not taken into account subparagraph 7, which discourages him from making a pure issue-based cost order. There is a passage which I think is in our skeleton, which is a quote from the case of English and Emery Reinbold at paragraph 56, which is to similar effect as to the difficulties in an issue-based cost order on detailed assessment, and the fact that a percentage order is consistent with the overriding objective of the CPR. So I don't say that he can never make an issue-based cost order, but he should have been very reluctant to go down that road, and on the facts of this case, there was no need for him to have done so. And so we say he should have decided who was the successful party. That was clearly us. He should then have decided in relation to the other matters whether there was a reason to discount those costs, whether it should have been a percentage order, and accept that he had a basis for discounting. But I've gone through why we say that that discount shouldn't have been that large, because if you approach it from the basis that they had to take the proceedings in relation to the event of default, then you look at it in terms of how much extra has been caused by running these arguments which failed. And that is, we say, a relatively small amount, and therefore the discount should be less. My Lord, I think those are essentially my submissions on the issue-based cost order. You have my submissions in relation to not having raised it with the parties first. Can I then come on to the question of indemnity costs? And I know your ladyship, for instance, has been involved recently in a decision of Thakkar, which I think was handed down yesterday, was it, or the day before?
Yesterday.
Yesterday.
Hot off the press.
Hot off the press. I don't know whether your lordships have had a chance to see that judgment.
Certainly I have, I don't know.
Yes, I've had a chance, and I've used it to scan it.
Yes.
I'm not as familiar as my lady or my lord.
No. The issue in
what's the ratio of the decision? As you've had
so
more time
it's really the summary of the applicable legal principles, which starts at paragraph 18. And the ratio of the decision, I suppose the main ratio of the decision is there's no default starting point that if you raise allegations of dishonesty, which you then fail on, that there will be an indemnity cost order unless the court departs from that starting point or departs from that presumption. There is no such presumption or starting point, but the court acknowledges that it will commonly be the case that if you raise allegations of dishonesty which you fail on, you may end up paying indemnity costs. The issue here, we say, on indemnity costs is there are two issues that we rely on. We rely firstly on the fact that the claim was brought founded on the dishonesty of LCL, in particular Mr. Stylianides, and that should sound in indemnity costs. That takes it out of the norm, which is the test, the fundamental test to apply. Yes, I have to grapple with Hussein's dishonesty in relation to that, but you have my submissions on that. It doesn't go to the heart of it, because the whole claim came about as a result of LCL's dishonesty. And then secondly, we say that the offers should be borne in mind in relation to that, the series of offers.
So it's out of the norm to ignore the offers?
Yes. And it's out of the norm to bring a claim founded on dishonesty in relation to the occupation issue. That is out of the norm. And it's the combination of those two. We say out of the norm, it would be sufficed by bringing the claim founded on dishonesty in that way. That's enough.
And you have to say, don't you, that as it is purely a matter of discretion, the basis on which the costs are awarded, that actually what the judge did is without the generous ambit
I accept
in these circumstances.
absolutely. But if one looks at the judgment on this at paragraph 18, it is in many respects inadequate. And I've been through that. It takes out the question of dishonesty, it simply takes it out. It discounts completely the offers by saying these things happen in litigation. And in my submission, it's flawed in that way. I'm within time, Just, so I will leave it there unless the court has anything further for me.
No. Thank you very much, Mr. Hutton. Mr. Wheeler.
My lords, my lady, I am going to deal with the various points in the following order, if I may. I'm going to start with the cross appeal on penalties. That logically precedes the question of the interpretation of the post repayment date interest provision, because of course that point doesn't arise at all if we're right on if default interest is enforceable. Then I'm going to deal with that question of interpretation, and then finally deal with the costs issues. First, issue-based costs order, and then the question of whether the judge was right to order costs on the standard basis. So, beginning with the question of the penalty finding. The court has already seen, of course, the provision for default interest, clause 6.6 of the facility letter, is for interest, default interest at 3% per month above the standard rate of 1% per month. And that default rate applies on the occurrence of an event of default or in the event of a failure to repay any sum when it is due. Now, the judge found that provision to be unenforceable as a penalty, and my challenge to that finding raises the question as to whether the judge applied the correct test as a matter of law for determining whether a contractual provision constitutes a penalty. And if I may, I'd like to start by looking at the passage in the June judgment that deals with this issue. It's in the core bundle behind tab 9.1 at page 128. And it starts at paragraph 195, where he sets out the relevant clauses, and then over the top of the next page, paragraph 198 to paragraph 200, he sets out some key passages from the Supreme Court decision in Cavendish Square Holding. And I'm going to come back to that decision in more detail in a little while, but it's worth just emphasising the way that both Lord Neuberger and Lord Hodge, as quoted by the judge, put the test. The question is, and I'm paraphrasing those quotes here, whether the secondary obligation is exorbitant, unconscionable, or out of all proportion to the innocent party's legitimate interest in performance of the primary obligation. It is the disproportionality of the penalty by comparison with the legitimate interest in performance that is the key feature. The judge then deals at paragraphs 201 and 202 very briefly with two cases, Ahuja Investments and Cargill International Trading, both of which are concerned with the penalty rule as set out in Cavendish in the context of default interest rates. And you will see that reference is made in paragraph 202 to a rule of thumb set out by His Honour Judge Hodge KC in Ahuja Investments. The justification for charging a higher rate on default, a higher rate of interest on default because of an increased credit risk, which is a point made at the end of 201. Then in 202, some comparison between the rate in Ahuja and the rate in this case, which the judge said was not of the order of magnitude seen in Ahuja. Then, critically in my submission, at paragraph 203, having just focused in the preceding paragraphs, and particularly at the end of paragraph 202, with the question of the level of the default rate. He then says at the start of 203, it doesn't seem to him that the analysis in fact gets that far. In other words, what he's saying there in my submission is that we don't get to the stage in this case of looking at the level of the default rate. Here, he says the question is whether the default rate protects the legitimate interest of LCL. So I'm going to come back to this in a bit more detail in due course. But in my submission, this is where the analysis begins to go wrong. The judge is not looking here at the Cavendish test. Is the default rate exorbitant, having regard to the legitimate interest in performance? But rather, is the default rate protecting a legitimate interest at all? And having posed the question in that way, at paragraph 204, the judge acknowledges that charging a higher rate on default can be justified by an enhanced credit risk of the borrower. But he then says he doesn't think that that's what's happening in this case. And he gives then in the following paragraphs a number of reasons. I'm going to come back to those, if I may, later. But I'm then going to pick it up at paragraph 209. And we see where he ends up. His conclusion is that the default rate, he doesn't believe that the default rate did protect any legitimate interest of LCL. He's not saying there that the default rate was extravagant or extortionate, having regard to the legitimate interest in the performance of the primary obligations of the borrower. He's saying that it did not protect any legitimate interest of LCL. And that's the basis on which he finds that the rate was penal. And that, in my submission, encapsulates where he fell into error. He ought to have recognised that there was a legitimate interest. And then he ought to then have gone on to ask himself the question, is the default rate extravagant or unconscionable, having regard to that legitimate interest? And that's the question that he just doesn't address at all. So having, by way of introduction, gone through the approach that the judge has taken, I'd just like, if I may, to turn to the relevant authorities, and in particular focus on those which are concerned with the application of the penalty rule in this particular context. And I'm going to start, if I may, with Cavendish, which will be behind dividers 13. I'm afraid I don't know if that's the first or second volume. It's page 280, so it may well be the start of the second volume. And although the report begins at page 280, I would like to pick it up, if I may, at page 352 in the judgment of Lord Mance. And I'm starting with him because he deals most directly with the question of default interest rates and the application of the penalty test in this context.
And sorry, which page or paragraph?
Page 352.
352.
Which is paragraph 144 at the bottom of the page.
Do we have to worry about who agreed with who in this case?
Well, I'm going to show my lord in due course
That's why I was frowning at you.
what the position is as regards that. It's slightly mixed. So I will take you through that in due course, if I may. But to answer, perhaps to give a more substantive answer to that question, I think although the different members of the Supreme Court expressed themselves in different terms, and there were a number of speeches, in substance, all of those set out the same test in my submission. They're not differing from one another substantively. There are differences of nuance, but they all effectively point in the same direction. And I think when one sees how Cavendish has been applied in later cases, one sees that as well, with subsequent judges quoting various bits from various different judges and saying, well, essentially, these all point towards this being the test. And that's why it's useful to understand how that test works, to look at the various different speeches in my submission. So just picking up at 144 in Lord Manch's speech, he begins by referring to a decision of the High Court of Australia from 1986, and comments that when that court was examining recent English authority, they thought that the underlying test of extravagance, exorbitance, or unconscionability, which came from the Clydebank Engineering and Dunlop cases, had been eroded by decisions which focused more narrowly on a comparison between agreed sum and any possible loss. And then he refers to the two decisions. And in the final sentence, he says, well, both of those cases accept a basic dichotomy between penal and compensatory provisions. And then at 145, he says, more recent authority suggests that this dichotomy may not be exclusive, and that there may be clauses which operate on breach and which are commercially justifiable, although they fall into neither category. In short, commercial interest may justify the imposition on a breach of contract of a financial burden which cannot either be related directly to loss caused by the breach or justified by reference to the impossibility of assessing such loss. So, of course, traditionally one has liquidated damages clauses, and the question being, well, are they a penalty? And what Lord Mance is recognising here is that there may be other provisions, other secondary provisions, which aren't liquidated damages clauses, but which provide for some financial consequence of a breach, but nonetheless, although not liquidated damages clauses, protect some other legitimate interest. And we see then that he quotes 146, the Lord's Vow finance case, which I think up to that point was probably regarded as the leading authority on default rates. And I'm not going to read the whole of the quote, but one sees, just picking up on some points, Mr. Justice Coleman, who gave the judgment in that case, noting at the start of the quote, the borrower in default is not the same credit risk as the prospective borrower with whom the loan agreement was first negotiated. So simply continuing the original rate doesn't reflect the fact the borrower no longer has a clean record. It says there's in principle no reason not to have an increase on default, not because it's a genuine pre-estimate of loss, which of course was the old test under Dunlop, but because there's a good commercial reason for deducing that deterrence of breach is not the dominant contractual purpose of the term. And then picking up the italicised wording at the end of the second paragraph of the quote, there would therefore seem to be no reason in principle why a contractual provision, the effect of which was to increase the consideration payable under an executory contract upon the happening of a default, should be struck down as a penalty if the increase could in the circumstances be explained as commercially justifiable, provided always that its dominant purpose was not to deter the other party from breach. And then in 147, in entirely general terms, Lord Mance picks up on the decision in Lord's Vow and says in a whole series of cases across the world, courts have taken their cue from that and held that, paraphrasing, default interest rates should not be regarded as penalties, save where the uplift is evidently extravagant. And that, in my submission, is put in wholly general terms and can be treated as applying in wholly general terms. Default interests provisions are inherently acceptable. They are inherently not penalties, subject only to the caveat that the uplift is not, to use Lord Mance's words, evidently extravagant. And one sees at paragraph 148, the rationale for that is given that default bears on the credit risk, may also bear on the cost of administering the loan. The uplift is conditioned on the breach, but the breach reflects directly on the continuing appropriateness of the originally agreed interest term. In substance, the uplift amounts to a variation of the original terms. If, on the other hand, it is evident from the size of the uplift that it is in its nature a punishment or deterrent to breach rather than an ordinary commercial re-rating to reflect change of risk or administration cost, then it will be disallowed as a penalty. And so that's where he focuses on default rates. If I could then ask you to turn on to the next page, paragraph 152. He says, the development of law indicated by the authorities discussed above is a sound one. He said it is most easily explained on the basis that the dichotomy between the compensatory and the penal is not exclusive. There may be interests beyond the compensatory which justify the imposition on a party in breach of an additional financial burden. And then he gives a series of instances where there may be such a legitimate interest, one of which, of course, is the revision of financial, this is at letter E, the revision of financial terms to match circumstances disclosed or brought about by a breach, Lord's Fowl and other cases. And we then get back to the test. What is necessary in each case is to consider first whether any, and if so, what legitimate business interest is served and protected by the clause, and second, whether assuming such an interest to exist, the provision made for the interest is nevertheless in the circumstances extravagant, exorbitant or unconscionable. And when he refers back to whether or not there is a legitimate business interest protected by the clause, that is in the context of him having given examples earlier in the paragraph of situations in which there is a legitimate interest for such a clause. Of course, that list isn't intended to be exhaustive. This is a general test. It could apply to contracts in any number of contexts, and there may be others that aren't listed here that are equally legitimate business interests. But one that is identified is the imposition of a default interest provision in a loan. So that is Lord Mance, and I just flag also the final passage of that paragraph, which refers to the positions of the parties negotiating at arm's length on the basis of legal advice being one of the factors that is relevant to consider when asking if the provision is extravagant or exorbitant. If I could then, if I may, turn on to Lord Hodge and pick his judgment up at page 376 of the bundle, at paragraph 221. Well, in fact, perhaps I just need to highlight at the top of page 221 there's a quote which starts on the previous page from Lord Dunedin's judgment in Dunlop Pneumatic Tyre. And he goes through the various aspects of that earlier decision. Point 2, picking it up at the top of page 376, the essence of a penalty is a payment of money stipulated as in terrorem of the offending party. The essence of a liquidated damages is a genuine covenanted pre-estimate of damage. And then 4A, there are various tests which may assist in the task, one of which is the penalty if the sum stipulated is extravagant and unconscionable in amount in comparison with the greatest loss that could conceivably be proved to have followed. And then at 221, Lord Hodge says, well, Lord Dunedin's first 3 propositions are stated without qualification. The first and third cause no difficulty, but the second causes difficulty when it has been treated as creating a dichotomy between a genuine pre-estimate of damage on the one hand and a deterrent in breach on the other. And he then says at letter H, the fourth proposition is prefaced with being tests that may be helpful in some cases but not others. But Lord Hodge then says, well, he thinks the proposition in 4A that I read out a minute ago is the essence of the test. And so essentially he's going back to Dunlop and saying, well, it's fine where the secondary obligation protects interests in obtaining damages for breach, but there may be other secondary obligations which protect other legitimate interests. And in that context, 222, he refers to Lord's Vale, and he sets that out, focusing on the question there of whether or not the uplift in interest was commercially justifiable. Then at 223 and 224, he refers to 2 other decisions of the Court of Appeal where, again, commercial justification is considered as the rationale for the acceptability of the provision. And then at 225, he says, in my view, this broader approach of Mr. Justice Coleman and the Court of Appeal involves a correct analysis of the law and escapes the straitjacket into which the law risks being placed by an over-rigorous emphasis on a dichotomy between a genuine pre-estimate of damages on the one hand and a penalty on the other. So that's an example, again, accepted by Lord Hodge, of an instance of escaping from that dichotomy, but nonetheless protecting a legitimate secondary, a legitimate interest in performance. And if I could invite you then just please to turn on to page 382. We have at paragraph 242 under the heading the true test. It says in paragraph 221 above, I had suggested that there was a problem in the way in which the courts had read Lord Dunedin's second proposition, and B, that his proposition 4A contained the essence of the test. That is, whether the secondary obligation was exorbitant and unconscionable. And again, we have there the essence of the test, as Lord Hodge puts it, is the secondary obligation exorbitant and unconscionable. And finally, at page 386, page 255, paragraph 255, forgive me, we have the first sentence, which is the sentence quoted by the judge in his judgment as to what the correct test for penalty is. But then it's worth also looking at the rest of that paragraph, picking it up at the end of that first sentence, where the test is to be applied to a clause fixing the level of damages to be paid on breach. An extravagant disproportion between the stipulated sum and the highest level of damages that could possibly arise from the breach would amount to a penalty and thus be unenforceable. So in other words, in the traditional liquidated damages type clause, we're not a world away from Dunlop. But in other circumstances, the contractual provision that applied on breach is measured against the interest of the innocent party, which is protected by the contract. And the court asks whether the remedy is exorbitant or unconscionable. So that again, the remedy exorbitant or unconscionable, measured against the interest of the innocent party protected by the contract. So it's the innocent party's protected interest that, as it were, provides the yardstick against which what is exorbitant or unconscionable is measured. Then, before turning to Lord Newberger, who gave the first judgment, if I could just show you first page 393. The short speech of Lord Clark, paragraph 291, where he says, 4 lines down, he agrees with the reasoning of Lord Newberger and Lord Sumption, Lord Mance and Lord Hodge. So he agrees, Lord Newberger and Lord Sumption gave a joint speech with which Lord Carnwath also agreed. And he agrees with them. So in one sense, that's 4 members of the 7 judge court in those judgments. But he also agrees with Lord Mance and Lord Hodge. And then if one looks at Lord Toulson, paragraph 292, he agrees with Lord Mance, or those paragraphs of Lord Mance, and the relevant paragraphs of Lord Hodge. And he quotes Lord Hodge statement in paragraph 255, highlighting what he says is the test. And it's then worth just flagging the comment he adds on that paragraph. Parties and courts should focus on that test, bearing in mind, A, that it is impossible to lay down abstract rules about what may or may not be extravagant or unconscionable, because it depends on the particular facts. And then B, that extravagant or unconscionable are strong words. So that, in my submission, supports what I said earlier about the judges, although there's a slightly complicated picture of who agrees with who, in essence, they're all speaking with one voice and directing towards a single test. So then finally, if I can come back, as it were, to the starting point of Lord Newberger and Lord Sumption, if I can pick that up, please, on page 309. Paragraph 26. Where we see reference to Lord's Vale and Mr. Justice Coleman's judgment and a quotation from that, and the fact that at paragraph 27, Lord Newberger then picks up on the same Court of Appeal decisions in Sinebes, Filmchilik and Murray and Leisure Play that Lord Mance had referred to. I'm sorry, forgive me, Lord Hodge, I think, had referred to. And then if I could pick it up at 28, he refers to Mr. Justice Coleman in Lordsvale and Lady Justice Arden in Murray, saying they were inclined to rationalise the introduction of commercial justification as part of the test by treating it as evidence that the impugned clause was not intended to deter. Later decisions in which a commercial rationale has been held inconsistent with the application of the penalty rule have tended to follow that approach. But then he says, a few lines further down, we have some misgivings about it. The assumption that a provision cannot have a deterrent purpose if there is a commercial justification seems to us to be questionable. And there's a quotation then from Lord Radcliffe in Campbell Discount. And at H he says, the penal character of a clause depends on its purpose, which is ordinary influence from its effect. As we have already explained, this is a question of construction, to which evidence of the commercial background is of course relevant in some ordinary way. And then finally over the page, he says, we consider that their emphasis on justification provides a valuable insight into the real basis of the penalty rule. It is the same insight as that of Lord Robertson in Clydebank and Lord Atkinson in Dunlop. Damages clause may properly be justified by some other consideration than the desire to recover compensation for a breach. This must depend on whether the innocent party has a legitimate interest in performance extending beyond the prospect of pecuniary compensation flowing directly from the breach in question. So we see there some misgivings about the application of a test simply of commercial interest. We see that the question is one of construction. And again, we see the emphasis on legitimate interest in performance. And it's legitimate interest in the performance of the contractual obligations. So again, that one throws one back on the question of, well, what were the contractual obligations and why does that give rise to a legitimate interest? And there is always a legitimate interest in the contracting party in protecting its right to having the other party to the contract perform the contractual obligations. That is almost inherent in the nature of a contract. And again, we see him referring uncritically to Lordsvale as an example of that. And then at 31 and 32, again, we have the passages quoted by the judge and the reference to what's described as the true test, being whether the secondary obligation, 32, whether the secondary obligation imposes a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. So again, the question is it unconscionable or extravagant? And again, as with Lord Hodge, the yardstick is the legitimate interest in performance of the primary obligation.
Do you accept the judge, in this case, identified the correct principles?
No. He erred in law, Lord, in my submission.
Well, in applying and identifying them or applying?
He quotes from Cavendish.
On the basis, presumably, of submissions made
Yes,
to him.
and on that footing, as far as it goes, the quotations from Cavendish are perfectly reasonable.
Well, was he referred to just to those passages he cites?
I don't know what he was referred to.
I mean, don't we have to give some latitude to a judge in these circumstances? Not expected to cite every passage from the authority.
No,
And
my submission is not.
if I can just finish the point, I may. The passage he cites do seem to identify the kernel of what you've drawn to our attention, even if they don't cover every single nuance of what the five judges said.
My Lord, I think that's fair in terms of the quotations, but where the judge, in my submission, gets into difficulty is in the approach he adopts to applying those principles.
Yes, well, that's.
And when we see how he does that, we see that the approach that he in fact adopts departs from the Cavendish test. I'm going to come back to develop that.
Your complaint is about the application rather than his.
Yes.
Thank you.
But in order to understand that, one needs to see in a bit more detail in my submission what was said in Cavendish. And indeed, I'm going to come on to the other two cases to which the judge also referred, because that one sees there how the penalty rule in Cavendish is applied in this context. I just want to also highlight if I may, paragraph 33 on the next page, which emphasises that the penalty rule is an interference with freedom of contract, and so therefore one shouldn't be too quick to describe something as a penalty clause. And then at 35, again, he says that the starting point is the parties are the best judge of what is legitimate. So that, I think, is all I need to say about Cavendish. And in my submission, it's plain from reading all of the judges together that one of the legitimate interests that can be protected by a secondary contractual obligation is a lender's interest in obtaining performance of a loan agreement and in having revised terms to reflect a changed risk and administration burden following the breach.
Sorry, would you say that again? So legitimate interest which can be protected.
But by a secondary contractual obligation is the lender's interest in obtaining performance of a loan agreement and in revising its terms to reflect the changed risk and administrative burden following a breach.
In obtaining performance of a loan agreement and
in having in revising the terms to reflect a changed risk and administrative burden following a breach. And that, in my submission, is by its nature a legitimate interest to protect. The only question is whether a particular clause and whether the protection given by that particular clause is in effect extortionate. And one can see that from both Cargill and Ahuja. And if I could turn to those, Cargill is at tab 16, I think again in the second authorities bundle, page 554. At paragraphs 1 to 3, we see how the hearing arose from a slightly convoluted procedural background. There was a claim for compensation under an agreement relating to the supply of some steel, and summary judgment was obtained in an amount of just over 61 million US dollars. And then when judgment came to be handed down, one of the issues was interest, and at that point it became apparent that there were issues over whether or not the contractual interest rate was penal, so that then had to be sent off for further determination and argument, and this is the judgment that resulted from that. And if I could ask you to turn on page 560, we see just above paragraph 37, the heading is clause 8.12, arguably a penalty, and the relevant passages from Cavendish are set out. I don't need to ask you to look at those because I think I've taken you through them, but on page 562 at paragraph 43, we see there that Mr. Justice Bryan says the question at the first stage is whether clause 8.12 imposes a detriment on the contract broker out of all proportion to any legitimate interest of the innocent party. In this regard, Cargill had a legitimate interest in ensuring that UTAM repaid the money Cargill had advanced, and at a time at which UTAM had undertaken to repay it. So he identifies the legitimate interest. And then at paragraph 44, he says Cargill submits the default compensation rate was not disproportionate or exorbitant in relation to that interest because it was commercially justified. The existence of a legitimate commercial justification means that the contractual provision is not disproportionate or exorbitant and therefore is not a penalty. Of course, we've seen in Cavendish, Lord Newberger was wary of adopting a commercial justification test, but one can see simply the pragmatic way of arguing it on the facts that if something can be said to be commercially justified, it's unlikely to be exorbitant. But we then have the quote from Lord's Bail, and paragraph 46, Mr. Justice Bryan says, although the language of Mr. Justice Coleman harks back to the original Dunlop decision, essentially his reasoning was approved in Cavendish. then at the top of the next page, he cites Mr. Justice Fancourt and Vivian Westcourt and Conduit Street, and he summarised the test as a three-stage test. First, is it a secondary obligation, which is not a question that arises here, we all accept it is. Question then identify the extent and nature of the legitimate interest, and then thirdly, determine whether or not, having regard to that legitimate interest, the secondary obligation is exorbitant or unconscionable. And in my submission, the Deputy Judge in this case stopped at the second of those three stages, didn't go on to address the third stage at all, having concluded at the second stage there was no legitimate interest. Whereas what he ought to have concluded, that there was a legitimate interest, and he should then have gone on to address the third stage. And then just finally at paragraph 50, Mr. Justice Bryan's conclusion there turns to the question whether clause 8.12 imposes a detriment on UTAM out of all proportion to any legitimate interest of the innocent party. It is self-evident in my view that there is a good commercial justification for charging a higher rate of interest on an advance of money after a default in repayment. The person who has defaulted is necessarily a greater credit risk, and money is more expensive for a less good credit risk than for a good credit risk. And again, it's striking in my submission that that proposition is put in entirely general terms. It's not specific to the particular circumstances of a particular loan. It is something that can be said to be generally true about all loans. And the key question then is, well, is the rate an exorbitant one? And the conclusion at paragraph 72 and 73 on page 566 is that on the facts of that particular case, the rate was not exorbitant, and therefore it was not a penalty. And then finally, if I can...
Well, I mean, this is a decision in the end on its facts, but it was a lower rate, was it? Or not?
I forget what the rate was on...
It certainly said, Mr. Justice Bryan says the default compensation rate is comparable and indeed lower than many such rates.
Yes, and I think... Yes, I think the... if one looks at page 564 and paragraphs 59 to 61, well, paragraph 61 refers to an uplift of LIBOR plus 12%.
And I think you find that at paragraph 4. In summary, Cargill submits that it's entitled under clause 8.12 to default
Lady,
compensation
yes.
at a rate of 1 month LIBOR plus 12%.
Well, lady, yes, I'm grateful you're ahead of me on that, but yes, that's absolutely right. Oh, I think my lord is correct in saying that whether a particular figure is extortionate in the particular circumstances of a loan, that obviously is something that turns on the facts of a particular case.
Yes.
Well, I don't emphasise those particular facts particularly strongly. If I could turn then to Ahuja Investments and Victory Game, which is at tab 18, page 616. And page 617, we have a summary by His Honour Judge Hodge, QC, of the nature of the claim that was before him. Trial for damages of 2 sets of fraudulent or alternatively negligent misrepresentations made to the claimant by the defendants during the course of the sale by the first defendant to the claimant of a commercial investment property in West London. Parallel claim for damages for breach of contract. The value of the claim is in excess of 8.7 million, less the sum of 800,000 advanced under a loan agreement which the claimant entered into with the first defendant on completion of the sale, together with £24,000 for interest, which had fallen due under the loan agreement before its purported rescission, which remains outstanding. So out of what is quite a long judgment, the penalty point arises from argument over that loan agreement. And the relevant passage starts at 647 towards the bottom of the page. where the judge at paragraph 131 and 132 outlines the issue. There's the only remaining live issue in relation to the loan agreement, the question whether the interest provisions within it constitute an unenforceable penalty. Describes a penalty as being one that operates on a breach of contract. And at 132 he says the starting submission was that particular provision wasn't one which operated on a breach of contract, and that submission was quickly rejected. And so one then gets into the parties' competing submissions on Cavendish and its effect. And if I could turn to 142, sorry, page 651, paragraph 143. One sees just at 142, while we're here, that this case involved a default interest rate of 12% per month. And you will recall the judge's comments that the rate in Ahuja was very much greater than the rate in this case. And that, of course, is why, because the rate here is 4%, the rate there was 12%. At 143, the judge then says, I accept that a lender has a legitimate commercial interest in applying a higher rate of interest to a borrower who is in default, because such a borrower represents an increased credit risk. And at 144, the real question for determination in any particular case is whether the borrower has demonstrated on the balance of probabilities that the default rate applied because of the increased credit risk presented by a defaulting borrower is nevertheless, in all the circumstances, extravagant, exorbitant, or unconscionable. And it's striking that this is a case where the judge decided on the particular facts that the rate was exorbitant, and therefore it was penal. But nonetheless, going back to the three-stage test in the way it's set out by Mr. Justice Fancourt, he does that on the basis of the third stage of the test. He decides that it was exorbitant. He accepts very readily that there was nonetheless a legitimate commercial interest in having a default rate. No suggestion that even though the clause was exorbitant, that it somehow failed at the second stage of the test. So where does that then leave us? In my submission, there are 5 key principles.
So we can put the authorities away.
I think we can for the time being. 5 key principles being, firstly, that the key hallmark of a penalty is that it is out of all proportion to the innocent party's legitimate interest in performance. Secondly, a lender has a self-evident interest in the borrower repaying its loan on time. Thirdly, there is a recognition in the authorities that a default rate is a legitimate mechanism to protect a lender's interest and to take account of the changed circumstances following a default, subject only to the default rate not being extortionate.
So I wasn't giving up. Recognition in the authorities that a default rate is a legitimate
mechanism to protect a lender's interest and to take account of the changed circumstances following a default. And that is subject only to it not being extortionate. Fourthly, the test is not, in my submission, a nuanced one. There is a high hurdle to establish a penalty. An exorbitant, an extortionate, and similar terms that we see in the authorities are strong words. Even if the precise line between a penalty and a non-penal default rate may be difficult to draw, a penal rate ought, in my submission, to be obvious when you see it. And finally, whether a default rate is exorbitant and hence penal is a matter of construction. And so it follows from that that the test is objective, not subjective. And it also follows that it is not dependent on the lender's internal rationalisation of the level at which the default rate is set.
Not dependent on the lender's.
Internal rationalisation of the level at which the default rate is set. So against the background of those authorities,
Just following up on that for a moment, a slightly different point. You say, I know the judge approached things wrongly as a matter of principle in certain respects. Would you accept that the decision whether or not something is a penalty has an evaluative element?
if one gets to the final stage of the test, is it extortionate? And I think I have to accept that that necessarily involves an evaluative element. And I know my learned friends refer to, I think, the decision of the Supreme Court in Re B as to how the court should approach an appeal against an evaluative decision. Ultimately, though, one still has to ask the question, well, is there something with the decision that is wrong? And if the judge has approached the matter by asking what is, as a matter of law, the wrong test, then that's, in my submission, good grounds for an appeal. And
I must say, at the moment, what you say makes sense to me. At the same time, generally, when you're dealing with points of construction, you don't give the judge any margin of appreciation. You decide whether it's right or wrong. And as you say, in a sense, whether or not something is penal is a question of construction. But it feels like a question of construction where there is an evaluative element.
well, I think I have to accept that's right. And if one can take, I mean, for example, if one takes a hooger, just as a hypothetical example,
That's the 12% case.
12%. If one came on appeal and said, well, the judge said 12% was penal, but actually he should have said it's only penal if you get to 13 or 14 or 15%, then that starts getting into the realms of challenging an exercise in evaluation.
Yes.
It may be that if one gets and says, well, it's not 12%, it's 50% or something like that, and you got it wholly wrong, one might be able to succeed. And I know those figures perhaps are slightly, don't perhaps make much sense, but my Lord, I hope gets my point. But this appeal really isn't making that sort of argument at all. My submission is not that the judge undertook the evaluative exercise that was required by Cavendish and made a mistake in the evaluation. My submission is that he didn't ask the question at all as to whether or not the rate was exorbitant or extortionate. He doesn't get to that stage. On his words, in his own judgment, he doesn't get to that stage of the analysis. He decides it at the earliest stage to whether or not there's a legitimate interest. And that, in my submission, is where he falls into error. And I was, having gone through the authorities, just going to go back to the judgment and look at that in more detail, if I may. And it's at page 130 of the core bundle behind tab 9.1. And I took my Lord and my Lady to paragraph 209 earlier, where he says, I do not believe that default rate did protect any interest of LCL. So he's not engaging with that test in Cavendish, as in my submission it should be properly understood in the context of default rates.
I mean, one possible element of the judge's thinking is, well, he's focusing on the default rate in relation to this particular type of default. Obviously, as a matter of drafting, the default rate applies much more widely. The judge isn't then saying, is there a legitimate interest in relation to the default rate more generally?
Well, the effect of what he's saying is that the rate is simply unenforceable.
Yes.
So it's unenforceable for any breach. And indeed, the breach in question here essentially was not repaying the loan when it ought to. I mean, I accept the findings of the judge that there wasn't a default as was alleged, and so forth. But the basis on which the respondent sought to apply the default rate was initially that there had been a default in terms of not repaying on demand when demand was made on the basis of non-residency. But one also has to recall what the judge says at paragraph 196 of the judgment on page 128. Because he starts at 195 saying, in one sense, he doesn't need to address this question at all, having reached the conclusion he did on breach. But he then says, well, it also applies, default interest also applies, if the borrower fails to repay the amount payable by it under any finance agreement on its due date. And he then says, to that extent that sums remained outstanding under the facility letter after the 7th of August 2021, the question of whether the default rate applies is a potentially relevant one.
So which paragraph are you there reading?
196, my lord, on page 128.
Back out.
So he is there actually very alive to the focus that it is whether or not the fact that there was a sum outstanding after the 7th of August 2021, in other words, whether the loan was simply not repaid when it fell due, is a key reason why the penalty question remained live, and indeed still remains live. So in my submission, it can't be right to say that the judge was simply focusing on one particular type of default. He was conscious that the reason that the question remained relevant was because of what in the context of a loan is the absolutely key default of not repaying when the money is due. And when one looks at 209, and even looks at the judgment as a whole, he doesn't find that the rate was exorbitant or extortionate. My learned friends in their skeleton argument say, well, one shouldn't overanalyse the words of the judgment, and such a finding must be implicit as a matter of substance. But in fact, the judge just doesn't, one can't see the judge engaging with that question at all.
Well, he deals with the legitimate interest point.
Yes.
At 203 and 204.
Yes, my lord, he does. He finds that the default rate doesn't protect any legitimate interest of LCL. But in making that finding, he overlooks that a lender does have a legitimate interest in securing timely repayment from a borrower.
So just pausing on those paragraphs, in 203, well, he says, 203, the middle sentence deals with the residency requirements, and that's to do with occupation and so on. And then he says, charging a higher rate on default can be commercially justified, but it does not seem to be that this was the interest that LCL was seeking to protect. So is he there saying, well, in relation to this particular breach, it wasn't protecting that interest? Or is he saying, more generally, where you have a default interest rate that applies where there has been a failure to pay, they're still not protecting?
Well, Lord, it's the latter. It's my reading of the judgment. He doesn't at all anywhere recognise that a default rate is inherently legitimate, either as a way of ensuring timely repayment, or as a means of reflecting changed circumstances following a default. And indeed, at 203 and 204, where he says, well, a higher rate can be justified, but that's not what we're doing here. In a sense, he's focusing on whether the default rate does protect the legitimate interest of LCL. And that, in my submission, really turns Cavendish on its head. Cavendish recognises that there is a legitimate interest in securing proper performance of the primary contractual obligations.
Well, do you have to read 204 and 205 together? In other words, is he saying that isn't the higher rate on default was not legitimate interest here because the higher credit risk justification in legitimate interest is already priced in to the higher base rate.
Well, except
I'm sure I put it too crudely, but that's what he's saying in 205.
I'm not sure if that's what he's saying in 205, but in a sense, that point looks at from the wrong perspective. When he talks about the credit risk being priced in, that's the pre-default credit risk. So that 1% rate, the normal rate, the standard rate, is what's applicable on the basis of the credit risk at the start of the loan, on the assumption that the terms of the loan are complied with.
Well, what he says about that is in the last sentence of 205, isn't it?
Well, it is.
He says there's no evidence to show. Given that there was the higher initial rate, base rate, there's no evidence to show why a late payment was and I'm using the word legitimate, was a legitimate interest justification for a further 3%, when 0.3% was sufficient to cover the historic credit risk factor.
Well, perhaps Laura, I can answer that by, as it were, taking a number of points stepwise. Because perhaps just looking back to 204, where the judge starts by rejecting the notion that one can simply justify this on the basis that a higher rate on default is normal to reflect the enhanced credit risk.
Can be.
My submission, that puts it too low. It is, when one looks at Cavendish and the authorities I've taken the court to.
Well, is always.
Yes, inherently, because...
Doesn't it depend on the circumstances of the case?
Well, on the premise that a lender will always have an interest in obtaining repayment in accordance with the contractual terms, assuming one takes that as inherent in the notion of a loan, then it's no law. It doesn't depend beyond that on the circumstances of the case.
I mean, actually, it's very hard to see how a failure to repay can't increase the credit risk. I mean, it's very hard to see how that prospect can have been entirely priced in on the basis of pre-contract knowledge.
Well, in my submission, it can't have been. One prices in the standard rate on the premises of where one is at the start of the loan, or the assumption that the loan will be complied with. If there's then, subsequent to that, a default on this particular loan, well, as my lord says, the risk changes.
So your complaint really should be focused at 205 then, shouldn't it?
Well,
because the fact there was a higher rate priced in was a reflection of existing other credit risks. The existing credit risk justified a higher rate, and the extra credit risks which would result from a default, in your case, ought to justify a high default rate automatically.
Lord, yes. And just to pick up, I do want, if I may, to go back to the closing words of 204, where the judge sort of rejects what might be said to be, what in my submission is the standard position. He says, it does not seem to me that this was the interest that LCL was seeking to protect. It's not entirely clear what he means by that, but in my submission, what he's doing there is adopting a subjective approach based on his view of what LCL was subjectively trying to do.
Internal rationalisation, to use the phrase.
My Lord, yes. Rather than
you invented.
Yes, rather than applying an objective test, as one would, to questions of interpretation, he's looking subjectively at what LCL does.
But I have to say, even then, I mean, I followed the way you put that, but even then, if you think about the default rate generally, as opposed to how it might work in this particular case, so the lender includes in its contracts generally something saying, if there's a default in paying us, we're going to put up the interest rate. It's very hard to see why that wasn't an interest that LCL was seeking to protect.
Well,
I mean, it's subjectively as well as any other way.
Well, of course, subjectively it would have been. But it's a question of construction. One's focus
Yes.
ought not to be
No.
subjective. But what this, as the judge goes off down this road of looking at LCL's subjective, as he sees it, their subjective approach, he overlooks the obvious fact, my submission, that LCL did have an interest, a legitimate interest, of adjusting the terms of lending to suit the new circumstances of default.
I mean, the problem I have with this part, this part of the judgment, for my part, is that these factors that he lists under 1 to 5, certainly the ones he lists under 2 to 2, 3, 4, in 206 to 208, they seem to go to the question of unconscionability and extortion, rather than to the question of legitimate interest. Yet he's listing factors, as it's drafted, which to justify his conclusion that there is a legitimate interest. So the point of, well, you see the point.
My Lord, yes, it may be that is the part of the reason why he takes a wrong turn on this.
I mean, the fact that the default rate is the same regardless of breach is a factor relevant to whether or not it's extortionate, arguably.
Arguably, I think
And the same default rate applies to all breaches, again, arguably. And the expert evidence point. Those go to the third part of Mr. Justice Fancourt's tripartite test. Not that he has the way it's drafted. They seem to come in at the second.
Well, they do come in the second, in my submission, my Lord. And the judge's conclusion expressly brings them in at the second stage. And
I mean, it's perfectly true. It's a matter of language. He brings them in at the second stage. Might my lord be right that actually he's looking beyond the second stage?
well, except that there's no indication in the judgment that that's what he's doing. Nowhere does he say language that, as a result of these factors, the rate was extortionate, or anything similar to that. And what he does say, on the other hand, is that LCL wasn't protecting a legitimate interest.
I mean, the more you look at it, from my part again, the more you look at 206, 207, 208, they look like an analysis of whether or not this default rate was extravagant. To use what I think is a slightly odd word, was extortionate, whatever word you want to use. It's a blunderbuss that applies at every possible breach. It applies to all breaches, and then you have the 208. The way 208 is drafted it's all about that, isn't it?
Well, my submission it's not, because what one sees, for example, at 205, the judge doing, when he says at the end, he says he had no evidence on why late payment, even by a short period, justified an increase of a further 3%, when 0.3% was sufficient to cover the historic credit risk factors. Well, firstly, he's looking there for a subjective rationalisation of that number, rather than adopting an objective approach to interpretation. We know that's wrong in principle in my submission. And secondly, when it comes to the level of the rate, the question is not, can it be sufficiently rationalised? The question is it objectively extortionate? And again, at 206, he refers to the default rate being a standard rate, set centrally at 3%. That, in my submission, cannot be indicative of a penalty at all. And indeed, at the end of 206, he says, if the legitimate interest were credit risk, one would expect some account to be taken of the security, but none was.
Is there a bright line between the question of whether or not there is a legitimate interest and the question of exorbitant?
My Lord, yes, there is. And as one sees from the authorities, legitimate interest is almost inherent in the nature of the lender's interests in the borrower's compliance with the loan agreement. It almost follows from the very fact Of course, the lender has a legitimate interest in obtaining timely repayment of the loan. And so answering that question ought, in my submission, to be very straightforward. One simply says, yes, of course there's a legitimate interest. One sees that approach adopted in Ahuja. One sees that by Lord Mance in Cavendish, when he says in cases all around the world, they've followed Lord's vow and accepted that default rates are legitimate, except where extortionate.
I'm not quite sure where this goes. The judge's complaint, to an extent, seems to be that this isn't individualised.
Yeah.
So the 3% is set not in relation to this particular lending at all, let alone in relation to any particular type of breach in this particular contract. It's set by the lender and applied across the board. So whether or not, I'm extrapolating now, whether or not in the abstract the lender might be imposing default rate to protect an interest that could be expected to arise from default. He's not doing so here because it's not looking at the particular circumstances, the extent of the security, the sort of particular breach that the judge is concerned with. It seems to be an idea along those lines.
That may be what the judge is driving at, but in my submission, that's wrong. It's not surprising that rates are set centrally. Vast majority of lending involves terms that in some way standardised. Nothing unusual or objectionable about that. It doesn't follow from the fact that the rate is a standard rate used by this lender in all its loans and wasn't considered by reference to this particular case. It doesn't follow from that at all that it's extortionate. One only has to hypothesise an example, supposing the default rate were 0.5%. We've seen evidence the market rate is fairly typically 3% per month. The fact that 0.5% was standardised wouldn't allow one to say that it was extortionate. It would be, on that basis, a very low rate. The question of whether or not it's standardised and applies generally is simply an entirely different question in my submission, to whether or not the rate is extortionate. And conversely, if it had been determined on an entirely bespoke basis, but was 50%, well, the fact that it was bespoke wouldn't change the fact that 50% was likely to be regarded as extortionate. They're separate questions in my submission.
And you say the legitimate interest question is almost, the box is almost ticked always in this circumstance, following, as you say, Cavendish, Lord Mance, Ahuja, Cargill, and then one looks at, is it extortionate? But here we've got there is no legitimate interest because of all these reasons which actually perhaps go to whether it's exorbitant or not, and therefore he never directly considers whether it's exorbitant.
Milady,
You would say it's always, practically always legitimate in these circumstances, and you move on to the last leg of the test.
Milady, yes, I think I accept everything your ladyship has just said, except for your ladyship's suggestion that what's said in these paragraphs goes to the question of exorbitancy. In my submission, it doesn't. It's not focused on that at all.
I mean, I see why you say that as a matter of language, but take my Lord's paragraph 208. How can that not be looking at exorbitancy?
Well,
Not my paragraph.
Well, it wasn't my Lord's paragraph in that sense, but he referred to it a moment ago.
Banged on about it.
well, I was going to make some points on 206 and 207.
Yes, go ahead.
Perhaps I can
Go
come
ahead,
back to
yes.
208 when I get to it, but I will certainly do so. I'm going to work through each of them in turn. On 206, I just wanted to.
Before you do, the last sentence, of 205, you say is nothing to do with anything. It's subjective after the term date.
Milady, yes, I
Yeah,
do.
okay.
I also say it's comparing apples with pears in looking at the pre-default standard rate against what rate might be appropriate following a default.
I mean, I'm not sure this is the same as the previous point, but you might also say, well, it's not relevant to ask whether the default rate is justified simply in circumstances where there is a short period of default. I mean, you can't expect a lender, can you, to produce a different default rate for a week's default, another one for a month's default, another one for a 3 months default.
This is where you started with Lord Mance, isn't it? Lord Mance makes the
Lord, yes.
what he says at 148 is the clearest exposition
Lord, yes.
in support of your case. It's just as he says. You say this is a case where it's evidence from the sign. You look at this. You look at the uplift. An uplift is justifiable because it bears on the credit risk.
Lord, it does. Yes.
And it's effectively a variation of the original terms, and it wouldn't. In those circumstances, it's impossible for it to be, as my Lord says, variable in more than a simple way.
My Lord, yes. For that, and actually a host of practical reasons. That it's very difficult. It'd be very difficult to try and do that exercise. And I don't think in any of the cases does one see that.
I'm sorry, I took you back to 205. You were on to 206.
My lady, yes, and I was just
Building up to 208.
Yeah. Let's take it on up.
Your timing will just be right.
I was going to pick up on the last sentence of paragraph 206, where the judge says if the legitimate interest were credit risk, one would expect some account to be taken as a security, but none was. So again, that demonstrates in my submission a subjective approach. He's almost saying when the default rate was set, the lender must have had something in mind other than the increased risk on default, and that something else was not a legitimate interest to protect by a default rate. He's again disregarding the inherent interest in securing repayment and adjusting the terms following default. And of course he mentions security, but what he doesn't mention is the time and trouble of having to enforce that security by comparison with obtaining the straightforward repayment of the loan on time. Then at paragraph 207, he says, well, the problem is that the same default rate applied to all breaches. He didn't in this context refer to evidence that a standard default rate is a standard default rate, standard approach adopted by lenders. That's in the supplemental bundle at page 252 behind tab 12, and it may be that I don't need to do more than give
This is one of the experts.
the reference, but yes, that's the transcript of the cross-examination of one of the experts, and the expert essentially says, well, it's always done this way.
Well, that's sort of implied in 208, isn't it?
Well, that perhaps 208 comes on to a slightly different point. 207 is, well, it's not entirely clear in my submission what point the judge is making when he says that applying the same default rate to all breaches would mean that LCL required identical protection for each of the following. The clause did provide identical protection for every kind of default, but that of itself doesn't mean that it was not serving to protect the legitimate interest in performance. And then to get on to 208, the judge here refers to the agreed expert position that the 3% default rate for loans of this kind was typical. And he says in terms, this is not a cap. But then what he does is question what the justification was in this case for going beyond the usual level of default rate. And in my submission, what that demonstrates he's looking for here is some specific rationalisation of this particular rate. He's asking, well, you get to 3% quite easily. What's the justification for the additional 1%? And that, in my submission, is the wrong approach. Because the question is not, is this rate adequately justified? The question is it extortionate? And while the fact that you can't give a good justification for it may in some circumstances demonstrate that a rate is extortionate, it doesn't necessarily follow that because a rate cannot be well explained, that it is necessarily extortionate. And this, in a sense, ties into the way that my learned friends put this point in their skeleton argument. They say the judge was right in the approach that he adopted, because the issue is not, was there a legitimate interest in imposing a default rate, but is there a legitimate interest in imposing this particular default rate? And effectively, by that route, the appellants argue that the judge was right in saying that there was no legitimate interest protected by this particular default rate because of the absence of sufficient rationalisation or justification for default rate at 4%. But by doing that, they effectively bring the level of the default rate into the assessment on the question of whether or not it was protecting a legitimate interest of LCL. So effectively they're saying, well, a default rate of 4% doesn't protect the legitimate interest of LCL, even if a lower rate might have done so. And that's wrong in my submission. And it's wrong because it effectively waters down the test that's applicable to the level of the rate, as it were, the quantitative test. You water it down from asking, as you should, is the rate extortionate, having regard to the interest it protects, to merely asking, is there a legitimate justification for this particular rate? And that's effectively asking whether the rate is acceptable by reference to a much lower test. And in my submission, that approach really reflects the judge's error.
I was going to say, that is what you're saying the judge has done. He's mixed the two elements together in those paragraphs.
Milady, yes, he's conflated the fact of the default rate, the level of the default rate, and the question of whether or not there's a legitimate interest on the part of LCL in securing performance of the loan terms. And he's therefore given the wrong answer to the second stage and not addressed the third stage at all. Lord, I note the time.
Yep. So you, I gather at lunchtime, we're estimating 3 hours. How are you doing? You're more or less at the end of penalty, aren't you?
I've got a little bit more to do on penalty, but not a huge amount. I'm about a third of the way through, so I'm broadly speaking on track.
Yeah, that's not on track for us to finish at lunchtime tomorrow. I know that you're being squeezed on time.
I'm certainly doing the best I can, my lord.
Yes.
And of course, the learned friends had rather more time than I suggested that I would be taking up.
Let's see where we get to. I'd be a bit surprised if there were that much more to say about penalty. You seem to have made your points.
Not a huge amount more. No.
If you can abbreviate your remaining 2/3. The question of construction is actually a very short question. The cost question is a rather more intricate one.
Lord, yes. I will certainly do what I can. I certainly anticipate taking less time than my learned friends have done between them.
Okay. 10:30 tomorrow, with, I'm afraid, the slight warning that there is this other matter of the hand down at 10, but I would hope that we'll still start fine at 10:30.